that I cannot conclude in the 3 minutes you have given me, but I appreciate it. If it is your ruling that this report stops at this level, I have no problem. I respectfully submit, and then I can leave, because there is no way I can. And I wanted just to finally, because as you also know, this may be possibly the last time some of us may be in this parliament. So I wanted you to protect that constitutional right, that little window that the people gave me to be in this house, to represent them. I just plead of you. I may not come back, ever. But that constitutional right for me to present, I wanted to ask that you give me.
Jonah, because you've actually spent the 35 minutes. Now, Jonah, I have always told you you're one of the people I will miss in this house. I am giving you an additional 5 minutes, and all the other minority reports, we will capture what is in your minority report, because the time has been taken.
Yes. Yes. You mark your reports. They mark their reports.
Right Honorable Speaker. Thank you so much, Right Honorable Speaker. I want to now go back to the report, but let the record capture that when I appeared in the committee, and you have, Speaker, as a member of Parliament, to sit in the committee of the legal, in the joint committee, I was not given the opportunity. The same treatment why I thought this house would allow me to present. So with that, let me just that the 5 minutes that you have given to me is not enough for me to present this, and I thank you, and probably take the opportunity liberation and representations. I know next week people are going to swear in. I want to wish you all the best.
Thank you.
Without prejudice,
Thank you. Problem. We shall consider
if you had been patient and read, it was going to come in the last page.
No, I am not impatient. Honourable members, I gave each side 35 minutes.
Yes. Right Honourable Speaker, I believe you will give me my right as a member who prepared a minority report that was co-signed by 2 other members, Honorable Adeke Ann Ebaju for FDC, District Woman Representative for Soroti, and Honorable Asumani Basalirwa, the MP for Bujiri Municipality. And my Right Honorable Speaker, our points of dissent are in the following areas. 1, the provisions in the bill that tend to infringe the freedom of expression, contrary to Article 29 of the Constitution. 2, the inconsistent mens rea, since several offenses of comparable severity, particularly clauses 8. Incidentally, this particular microphone seems to have been tampered with, and mine has, so as clauses 8, 10, and 12, and 22, that remain strict liability, while others require intentional knowledge, and creating an internal inconsistency contrary to Article 28(3) of the Constitution. I hope the answer will capture me. Yes? At Satura, number 3, Satura definitions in respect of foreigner and agent of foreigner, which cross-refer to clause 2, which in itself raises
Wilfred, that we will discuss that at committee stage. I will allow you to bring your issues.
Number 4, Right Honourable Speaker, is on criminalization of free speech. Number 5, and most importantly, Madam Speaker, this particular bill tends to infringe Article 1 of the Constitution by 1, trying to invert the sovereignty of the people into the sovereignty of the state. Article 1 of the Constitution refers to the people of Uganda being sovereign. What the state has is the authority to administer. So the title of the bill itself tells the lie about itself. And when you go through the bill, Right Honorable Speaker, apart from clause 5, which talks about the sovereignty of the people of Uganda, the rest of the clauses are in respect of the sovereignty of the state.
Okay.
And when we go to committee stage, Madam Right Honorable Speaker,
So we
have many amendments to make.
No problem.
Since we were never given an opportunity in the committee stage,
Thank you.
we have amendments to make on almost all clauses in the bill.
Thank you.
May I invite my other colleagues who have minority reports to make their presentations.
Members.
Thank you.
Madam Speaker, I have something to tell you. Madam Speaker, in my capacity as the Shadow Minister for Internal Affairs, I went to the committee with a request to make a presentation. Madam Speaker, I happened to arrive before the Attorney General. The chairman of the day, Honorable Baka, requested me to wait for the Attorney General to present so that I could also be given time. After the Attorney General had made his presentation of amendments, Honorable Baka ruled that I will make my presentation while at Munyonyo. When we reached Munyonyo, Madam Speaker, Honorable Kajenje ruled that my request had been overtaken by events. Madam Speaker, I chose to write a minority report because the issues I was going to raise had not been raised by anybody else. So I wrote a minority report, Madam Speaker. Madam Speaker, you are now ruling that there is no time. Madam Speaker, as a member of the committee, I'm not supposed to debate. Madam Speaker, there was a memorandum that came from Buganda Kingdom. Madam Speaker, when we reached Munyonyo, the memorandum went missing. Madam Speaker, they have told you here. Let me tell the Speaker. Madam Speaker.
Honourable members, they give Betty time. Some order.
Madam Speaker, I've heard the chairman telling you that when we were at Munyonyo, we heard from the Governor Bank of Uganda. And you know, Madam Speaker, I was so surprised because while the rest of us were in Munyonyo, we were never informed that even the Governor of Bank of Uganda had gotten back to us. Madam Speaker, because of those many issues, we are also told that 700 people sent memorandums to the committee, but only 47 of them were accounted for. I feel so silenced. Is it your ruling that the people from Mukono should not be heard on this?
Honorable Betty. Honorable Betty, my sister. The people of Mukono have been heard. You've spoken for over 5 minutes. You've raised your issues, and we are going to address all of those issues. Honorable members, we have all these supplementaries, and not supplementary, but minorities. We are going to go committee by committee. And all of you are saying you have issues on each clause. Why don't we look at clause by clause? Honorable Odur has raised pertinent issues. Let's look at...
Madam Speaker, let
Yes,
the record be clear.
Honorable Ogun.
You denied me opportunity to present. Don't use my name. Don't use
Honorable
my name.
Ogun.
No, don't.
Honorable Odur, you took all the 35 minutes. Honorable Lanya.
Right, Honorable Speaker.
Honorable Lanya, let me give you 5 minutes. Lanya, let me give you 5 minutes.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I'll go straight to the point of dissent. Right Honorable Speaker, the minority, following Rule of Procedure 105 of Parliament, Right Honorable Speaker, the bill establishes an extensive regulatory and criminal framework governing individuals and entities classified as agents of foreigners, imposing control and funding policies, policy engagement, and civic participations. The minority observes the several provisions, raise several concerns, including the vagueness and inconsistency of definitions, an extreme and disproportionate penalty regime, infringements on freedom of expression and civic space, duplication of existing legal framework, and the absence of commencement and the transitional provisions and duplications of the existing legal framework. Right Honorable Speaker, when the committee engaged with many entities, you recall we engaged with about 53 entities. Out of the 53 entities, 52 were in support of this bill. 51, including Bank of Uganda, religious leaders, among others, were telling Ugandans that this bill, when passed, it will create economic instability in Uganda. That was the word from the governor of Bank of Uganda. Right Honorable Speaker, this bill, it creates extreme and disproportionate penalty regime. The bill establishes a uniform and severe penalty structures, imposing custodial sentences of up to 20 years in prisons across wide range of offenses. Notably, the same maximum penalty applies to promotion of interest of foreigner. If you look at clause 5. Right Honorable Speaker, participation in activities deemed to promote foreign policy. That is in clause 10. Publication of information characterized
Gilbert,
as
we have
economic
now
substance.
we have gone to clauses.
Thank you, Right Honorable Speaker. Right Honorable Speaker, because of time, let me go straight to the recommendation. Right Honorable Speaker, this minority came out with the following recommendations. Having engaged and got many views from Ugandans, the minority recommends that the House does not pass the bill in its present form. 2, the bill be withdrawn and remitted for comprehensive redrafting. 3, a revised bill should provide clear and precise definitions, establish a proportionate penalty regime, aligned with existing legal frameworks, be be supported by a credible economic and fiscal analysis. Right Honourable Speaker, the view of the minority is that the bill should be withdrawn. I beg to move.
Honourable Betty. Betty, 5 minutes.
Thank you, Right Honourable Speaker. Right Honourable Speaker, the points of my dissent are as follows. 1. Right Honourable Speaker.
Switch on. Switch on.
Right Honourable Speaker, it is my opinion that there hasn't been enough public hearing accorded to this bill. Right Honourable Speaker, you have been told that 57 memorandums were reviewed. But the fact of the matter, Right Honourable Speaker, is that the committee received over 700 memorandums. One of them, Right Honourable Speaker, as I've put it, being from the Buganda Kingdom. Right Honourable Speaker, when we went to Munyonyo, we are given time to go and study these memorandums on WhatsApps, but when we returned to the committee, Right Honourable Speaker, the committee did not give us time to make a presentation, as I've told you before. Right Honourable Speaker, it's not about allowing people to come to the committee. The purpose of the people coming to the committee is to give their opinion space. The people should be heard. But we are handling, my point of dissent is that the committee ruled in favor of only 2 people out of the 700 who opposed the bill, Right Honourable Speaker. Right Honourable Speaker, we are here fidgeting with time. This is not legislation according to our rule of procedure 135. According to our rule of procedure 135. Recommendation, Right Honourable Speaker.
Are we speaking the same English?
Madam Speaker, I'm reading the report and you are giving me advice. I take your advice, Madam Speaker, but I continue to read my report.
You read. Yes.
I seek for your approval.
You finish. You continue with the report. Continue.
I seek for your protection.
Members, there's an order from WOPA.
So, the point of order that I'm raising is that, is it in order for members to make noise when a member is submitting? Is it it's okay to laugh, but let us laugh and allow the member to read her report. We now can't hear what she's actually reading. So, Madam Speaker, is it in order for members to continue shouting when a member is actually reading her report?
You are the one who was shouting. Honorable Betty, can you? Let's hear Honorable Betty.
Thank you, Right Honourable Speaker. I don't know why this particular microphone is low.
Please go ahead. At least I can hear you.
Right Honourable Speaker, my suggestion, my recommendation is that this, to make meaningful contribution to the debate and to accord Parliament enough time to handle a bill of this nature. Right Honourable Speaker, the Commonwealth practice is that parliaments which are about to retire don't handle controversial business. It's a practice, Right Honourable Speaker, and we are part of the Commonwealth, Right Honourable Speaker. The fact of the matter, Right Honourable Speaker, why that is required.
Which page are you in?
I'm reading page 3, Madam Speaker.
I'm not, and I'm following your report.
Madam Speaker, I move that this House finds that this bill violates the Constitution, rules of procedure, and the Parliamentary Convention, and that this House declares that the denial of the main report offends Rule 245 and 215.
214 and 215.
214 and 215. That it also declares that clause 2, 3, 5, 8, 11, 12, 24, 25, 30 are void for vagueness and the unlawful delegation of powers. That this Parliament rejects the joint committee report by the majority. I therefore also recommend that the movers of the bill withdraw the bill under Rule 141, defer the subject to the 12th Parliament with proper consultation, direct must affirm the sovereignty in the people under Article 1, define all key terms.
First of all, Rule 141 is on procedure
141. Rule 140.
Sub-Rule 1.
Sub-Rule 1. That directs that any future bill must affirm that the sovereignty belongs to the people under Article 1, and that key terms in the bill are properly defined, that is, the interest of government, the government policy, what constitutes the actions that make one an agent of a foreigner, and that the minister is not given powers to alter the offenses under the bill as it is. It is my prayer that the protection of the Sovereignty Bill 2026 fails the test of the constitutionality, legality, and procedure. The 11th Parliamentary Final Act should be to affirm the supremacy of the Constitution, not to legislate excessively. I so pray.
Thank you, thank you. Yes, there is procedure matter from
even to those with the minority reports to present. It is in the interest of this country that all the voices of Ugandans are heard in this House. And those who have spoken represent those voices. Right Honorable Speaker, Honorable Jonathan Odur did say he wanted to make a presentation in the Munyonyo, but he didn't have enough time. Or he was not given the opportunity. And now that he has very, very, very many issues that he would love to present, together with the rest of his colleagues, and those who may feel there are procedural matters that were not handled well, but now we have the opportunity to look at this bill in a proper detail, provision by provision. I beg to move procedurally.
So what have you spoken?
I therefore want to...
I am asking, what have you spoken?
Kiwanuka.
Kiwanuka.
I'm raising a procedural matter.
Kiwanuka.
I was raising a procedure.
Kiwanuka. Honorable Kiwanuka Fai. Honorable Kiwanuka.
Of dissent, and they are on page 2. Some of them have been highlighted briefly, but my approach was different. The point which has been left hanging is, Right Honorable Speaker, is starting from page 20. And that is where I am.
Let's have order.
Right Honorable Speaker, the minority have 140 of the rule of Parliament to withdraw the bill, incorporate the proposed amendments, and have the bill reintroduced for the first reading. The Attorney General can act on behalf of the minister on such a matter. If he agrees with such, so that they withdraw the bill for the withdrawal of the Public Service Pension Funds Bill, noted that therefore, once we allow the minister, they will go back and incorporate both issues in the minority report and those in the majority report, and you again subject them to the public. The biggest legislators are members of the public because we take their views and incorporate them into the clauses. In light of the above, Right Honorable Speaker, in light of the above ruling, the minority calls upon the presiding officer to comply with the earlier precedents of the House, which by virtue of Rule 8.2 in light of the above, the Parliament, which directs that the Speaker's ruling form part of the rules of procedure.
The ruling of the former Deputy Speaker necessary to report to bill. I asked the first question, do we have an alteration on the object of the bill? And the question was no. And what right Honorable Jacob Olanya, rest in peace, meant
me to mislead you as in one way or the other. Right Honorable Speaker, as I'm winding up, of course, the issue that the bill was rejected by the President and the majority of the stakeholders, that has been highlighted. The President of the Republic of Uganda, in the letter he wrote.
He's supposed to write it to Parliament, because it's Parliament who is holding the bill.
Right Honorable Speaker, the President wrote to the Bazukulu. And
Are you a Musukulu?
Yes. The minority, Right Honorable Speaker, as I'm concluding, let me conclude, honorable members. Let me conclude in just 2 minutes. Just 2 minutes. The minority notes that 224 stakeholders the committee interacted with, only 2 stakeholders, being Asimwe John, the resident of Fort Portal, and the Honorable from Mawokota, Honorable Nsibambi, supported the bill. In addition, the minority also notes that His Excellency the President gave directives in his letter over his, which was posted on X, in respect of this matter. And I call upon, in my final statement, I call upon this House, this House, and I recommend as follows. The Protection of Sovereignty Bill 2026, that was read for the first time and referred to the Joint Committee on Wednesday 15th, be rejected for the reasons listed above. Among others, I have only read one, but there are 6. Others which have been left behind. The report is very clear, uploaded. The Protection of Sovereignty Bill be withdrawn since it serves no purpose. The government is encouraged to consider providing remedies for matters affecting real societies, and the government undertakes to take practical steps to protect the sovereignty of the people from direct and indirect attacks to the sovereignty. And finally, Right Honorable Speaker, the rules of procedure be amended to ensure that no legislation can be proposed by the President or processed by Parliament after the general elections. Thank you, Right Honorable Speaker.
You mean after the general election you cease to be MPs? This country does not stop there. Procedure.
Thank you, Right Honorable Speaker. Right Honorable Speaker, this Parliament considers all our kingdoms very important, and they are great partners when it comes to making our laws when they present their views. In the presentation of the minority report by our honorable colleague Namboze, she mentioned twice that the views of Buganda Kingdom got lost.
I have not opened the debate yet. First wait.
I was just saying.
First wait.
No, want it to be withdrawn from the Hansard. It is bad. Yes, we want it to be withdrawn.
Honorable Daddy, you have only 2 minutes.
Right, Honorable Speaker, in the law that I studied, in that I taught some people, some of whom are in this house, there is room for accepting under protest. I want to accept some of your directions because you are the Speaker, but under protest. Number one is lumping me up with people I have opted to disagree with, and therefore saying, all of you minority, you are lumped up together and you are given the same time. That's number one. Number two, that even where you, Right Honorable Speaker, and with immense respect, do not contain your members, you allow them to present for more than the time you had originally apportioned for all of us. Then when I come, you say 2 minutes. I know that in my wisdom, collected by age, among other things, I am able to present this in those 2 minutes or 5. But I also know that the country will not benefit. With that said, Right Honorable Speaker, let me thank my colleagues that have presented before, both majority and minority. Let me also associate with the bulk of the minority presentations to avoid repetitions. Why I opted to disagree with some of them, including the minority, is that I did not read any amendment purportedly presented by the Honorable Attorney General. My construction and understanding of the presentation by the Attorney General, I read it, I know he skillfully wrote in small words views of the Honorable Attorney General, and then in big letters on the Sovereignty Protection Bill. But I treat them not as an amendment. However, I treat them as views of a stakeholder. Yes. Reasons or points of dissent. I have summarized at page 1 the reasons for my dissent. Insufficient consultation on the bill by government and the committee. The bill inverts the constitutional concept of sovereignty in favor of the state in contravention of Article 1. The bill is accompanied with an incurably defective certificate of financial implication. The bill infringes various principles and articles of the Constitution. The bill does not cure any mischief and is therefore misconceived. The bill is redundant as there exists sufficient legal framework to cure any mischief. At page 2, Right Honorable Speaker and colleagues, 3.1 on insufficient consultation by the government and the committee, I have stated what you're able to read, but with emphasis on Article 1. I also emphasize that the consultations were conducted here and we've never moved anywhere outside Parliament, as if the rest of Ugandans have no views to contribute on such an important subject. Sadly, influencing government policy is sought to be criminalized in this bill. See clause 7.4 of the bill. Right Honorable Speaker and colleagues, at page 4, I traverse the reasons that I have given, and I cite the case of Malema Biris and others versus Attorney General, Constitutional Petition number 2 of 2018, and the decision of court to the effect, in summary, that consultation is not cosmetic, but goes to the root of our constitutional governance. In 3.2, that the bill inverts constitutional concept of sovereignty in favor of the state and contraventions of Article 1 of the Constitution, I associate with the elaborated submissions of my colleagues to avoid wasting time and eating much into my 2 minutes. 3.3, Madam Speaker and colleagues, the bill does not cure any mischief and is therefore misconceived. And the summary of this, one is that there exists sufficient legal framework. But if you look at page 6 of my submission, it is sought to be understood that interference with the development and implementation of government policies and programs, which interference is funded by foreigners and agents, is the mischief. That foreign aid to civil society that comes along with conditions and parallel programs which conflict with government programs, this has given external donors, I understand, significant influence over the Uganda's political, social, and economic landscape, which has resulted into erosion of our values. See that the use of online platforms by foreigners and agents of foreigners to disseminate information facilitates social discord. The minority, and that is me now because it is a single man's minority report, note that the bill is misconceived since it is based on the wrong premise, that Uganda has no specific law upholding sovereignty of the country, which has resulted into continuous interference in the government's policies and programs by foreign countries and agents of foreigners. That no laws exist on the book to regulate activities of civil society, and that the law regulates the use of online platforms. I note that, 1, the Constitution only guarantees sovereignty of the people as against the state. No wonder the laws of Uganda are silent on this matter. There exist laws which include, among others, the NGO Act, the Man Laundering Act, and the Penal Code, which are sufficient to guarantee our security and sovereignty. In addition, I note that the bill further is misconceived because it restricts funds procured from abroad, thereby indirectly affecting the operations of financial institutions and the Bank of Uganda. Let me note that the majority report was uploaded yesterday at 4, so this one is taken care of. And for that matter, I will proceed to the next. It creates a regulatory arbitrage by extending the bill to persons and institutions already regulated by other acts of parliament. For emphasis, honorable colleagues, each and every sector we are talking about is regulated, including the political sector, which is sought to be the target of this. And you are able to read for yourselves A up to K at page 9. Right, Honorable Speaker and colleagues, although the bill seeks to safeguard the sovereignty of Uganda from external influence, it grants agents of foreigners, once registered, the right to interfere with sovereignty. For instance, an agent of a foreigner who registers with the minister can implement government policy or government services under Clause 6, strangely, can influence development of policy under Clause 7, can implement government policy under Clause 8, can interfere with the electoral process under Clause 11, simply because of registration. All the activities that are allowed for an agent of a foreigner under the bill will affront Article 1 of the Constitution, whichever way you look at it, even when the minister allows. It is an affront. And the bill assumes that what is offensive to the Constitution becomes lawful simply by allowing it under an act of parliament, insofar as they will infringe the sovereignty of the citizens of Uganda by subjecting it to the influence of foreigners. The so-called acts allowed under the proposed law will still be offensive by their nature, being an affront to sovereignty. The minority note, therefore, that had the bill been conceptualized properly, indeed by being overly vague and ambiguous in relation to its application and the activities it seeks to regulate, it may be declared void for vagueness and the stretching beyond the parameters of the Constitution. At page 9, the bill infringes several articles. My colleagues have mentioned quite a number specifically Article 1. I also opine that it offends Article 259 to the extent that it seeks to amend the Constitution by infection. This was canvassed in Paul Semogere Zakalo Luma and Juliet Reina Kafire versus Attorney General, Constitutional Appeal number 1 of 2002, in which the Supreme Court declared Section 5 of the Constitutional Amendment Act 2000 as unconstitutional since it had the effect of amending Article 28, Article 41(1), and Article 44(c). Right Honorable Speaker, in that case it was declared unconstitutional for having been passed without following the procedure under Chapter 8 of our Constitution. Court also discussed the effect of Section 5 of the Constitutional Amendment Act, which proposed to introduce new clauses 2 and 3 of Article 97 with the intention of restricting citizens' unhampered access to information in the possession of the state. You may read for yourselves, and I'll proceed to page 12. The bill infringes on the following articles of the Constitution, making it grossly unconstitutional in form and effect. Number 1, unconstitutional deprivation of citizenship. Right Honorable Speaker, citizenship is not granted by statute. By seeking to reintroduce the foreign element against Ugandans, the bill offends Articles 9, 10, 11, 12, 13, 14, and 15 of the Constitution. Freedom of expression under attack. Article 29, 1A and B, which provide that every person shall have the right to freedom of speech and expression, freedom of thought, conscience and belief. Now clauses 5, 7, 8, 9, 7, 8, 10, 12, and 13, and the definitions of disruptive activities in Clause 1 directly criminalize expression and association, including influencing the public to oppose the policy of government in a riot or unlawful demonstration or assembly. The definition of disruptive activities is offensive, and publishing information said to weaken the economic system, Clause 13. These restrictions are neither demonstrably justifiable in a free and democratic society as provided for under Article 43(2)(c), which provides that public interest shall not permit any limitation of the enjoyment of the right and freedoms prescribed under the Constitution beyond what is acceptable and demonstrably justifiable in a free and democratic society. 3. Freedom of association and assembly threatened. Right Honorable Speaker and colleagues, Article 38(2) of the Constitution guarantees every citizen's right to participate in peaceful activities to influence the policies through civic organization. Now listen to this. Clause 7(3), Clause 8(3), Clause 8(4), and 12 substantially burden and in some places extinguish that right by criminalizing conduct that constitutes its core exercise. 4. Right of equality invaded. Under Article 21(1), all persons are equal. Now, when it comes to the definition of foreigner, a Ugandan citizen residing outside, that has been sorted, and I accede to that. Then the foreigners in their own country and converts persons into those who deal with them. Intrusion of privacy, where the minister, the right to privacy of a person and property, and no person is subjected to unlawful search or unlawful entry into the premises. Clause 28 confers the person appointed by the minister to inspect the premises on an agent of a foreigner. Void for vagueness. I think the Honorable Betty Namboze has hinted on it, on the wide and arbitrary provision. Authorities to look at are Andrew Kalamaji versus Attorney General, Constitutional Petition number 5 of 2016, which struck down Section 25 of the Computer Misuse Act, Charles Onyango Bo and another versus Attorney General, Constitutional Appeal number 2. The bill departs from the legality principle under Article 28. Interests of Uganda, I think Honorable Namboze has hinted on it, they are not defined. Agent of a foreigner, clause 1. The definition is extraordinarily broad and captures any person who acts at the order, requests, under the direction and control. I have specifically highlighted the threats that I consider legitimate in those bullet points at page 14. Now, the foreigner clause, I think, has also been canvassed together with disruptive activities and economic sabotage. At page 16, Right Honorable Speaker, I have highlighted the threat against the freedom from cruel, inhuman, and degrading treatment in the attendant authorities. The bill is accompanied with a defective certificate that has been canvassed by the Honorable Odul Jonathan, and I want to associate with him, but point out or be specific on the following areas. 1, that the estimates of revenue and expenditure over the period of not less than 2 years after the coming into effect of the bill, when passed, the impact of the bill on the economy are not canvassed in the certificate. The certificate simply laid down the principle of what we may achieve in broad terms without telling us what we are likely to spend on implementing and whether government is prepared to spend that money. To that extent, the certificate is incurably defective and cannot support this bill. The bill has also the potential to destabilize Uganda's balance of payments. I think reference has been made to the submissions of the Governor Bank of Uganda, and I associate in the same terms. The financial sector and de-risking the operational paralysis, the capital requirements and the funding gap, the policy framework inconsistency and the voluntary shocks have all been canvassed. And then the second last is the amendments proposed by the committee, good as they sound, are equally excessive and disregard the precedents of the House. They also disregard the procedure that ought to have been adopted as elaborated by my colleagues earlier. Finally, Right Honorable Speaker, for my reasons, this is where I'm going to refer to the letter written by my brother, the President. And here nobody will ask me whether he wrote it or not, because having said he's my brother, I think I know him better than anyone. The bill was rejected by the President